Hello and welcome to a new episode of Legal Wrangle on direct tax. Today, we bring you decisions relating to liability of TDS on payment of lease premium, income earned from surrender of tenancy rights, delayed filing of TDS returns, chargeability of overseas credit and applicability of section 194C on payments made under legal obligations. Our first case relates to the lease premium paid by the assessee for obtaining the lease and acquiring leasehold rights. The key issue in this case was whether the sum paid by the assessee as lease premium had any nexus with the market rent of the property leased to the assessee and hence liable for deduction of TDS under section 194I. The assessee in this case is a private limited company engaged in the business of real estate investment. During the relevant year, MMRDA, a body corporate constituted and established under Mumbai Metropolitan Region Development Authority Act, leased out a plot of land to the assessee for a period of 80 years. However, the lease deed was executed after payment of the lease premium. Neha brings us the case details.
A notice was issued requiring the assessee to show cause as to why payment made to MMRDA was not covered by the TDS provision under section 194I. In response, the assessee claimed that the lease premium was not covered under the annual rent as it was paid only for obtaining lease and hence it would not attract section 194I. The revenue, however, concluded that the lease premium was in fact an advance rent and the assessee was required to deduct TDS on the same. As the assessee had failed to do so, it was treated as in default. On appeal, the CIT appeal reversed the order of AO and held that the lease premium paid by the assessee was for acquiring the rights for exploitation of the property. Hence, it was held that the premium was not paid under the lease but was paid as a price for obtaining such lease.
The matter reached before the tribunal, which also upheld the order of the CIT appeal and answered in favor of the assessee by holding that when the terms of lease deed clearly stated that lease premium was for acquisition of leasehold rights rather than use of land, no liability of TDS under section 194I could be attached to the case of assessee. The tribunal further observed that lease premium paid by assessee had no connection with the market rent of leased property, as the entire lease premium had been paid before execution of the lease deed. Thus, such lease premium received as a condition precedent for parting with the land in favor of the assessee was of capital nature and did not attract liability of TDS under section 194I. Our second case relates to the incidental use of tenanted premises under an agreement for use of looms and machinery placed in the said premises. The key issue in this case was whether incidental use of tenanted premises under an agreement for right to use looms machinery kept in such premises would be construed as sublease of the premises. Further, when consideration received on account of surrender of such tenancy rights would be chargeable to tax under the head income from other sources or capital gains. The assessee in this case had entered into an agreement with Messrs. Modern Textiles and Silk Mills Pvt Ltd for use of looms and machinery and accordingly took occupation of the subject premises where the looms were placed. The agreement provided that the assessee was granted use of the subject premises only as a licensee, incidental to its use of the looms, and such agreement cannot in any manner be construed as a sublease of the subject premises. Let's go to Neha for details of the case.
During the relevant assessment year, the assessee under an agreement surrendered its occupation of the subject premises to Praveen and Rajesh Makwana upon receipt of the consideration. It offered the same as long-term capital gain and accordingly claimed exemption under section 54 EC. The department, however, held that consideration received on the account of surrender of tenancy rights would be chargeable to tax under the head income from other sources. On appeal, the tribunal concluded that surrender of occupation was surrender of tenancy, that is capital asset, and hence the amounts received would be taxable under the head capital gains.
The matter reached before the High Court, which answered in favor of assessee by holding that consideration received on surrender of occupation or premises had to be classified as capital gains because assessee could be considered as a tenant of premises, as even incidental use of such premises would be construed as its occupation, and thus giving up of its occupation would be treated as surrender of capital assets. The High Court further held that the assessee can claim itself to be a deemed tenant under Section 511 and 15A of the Rent Control Act because he was in possession of the premises on 1st February 1973. It follows that assessee in the instant case is a deemed tenant and such tenancy being property would be a capital asset and consideration received on the surrender of the same would be capital receipts chargeable to tax under the head capital gains. In a third case, the assessee, namely Sibia Healthcare, had filed a delayed tedious return. The issue in this case was whether fees can be levied against the assessee under Section 234E for filing of delayed tedious return in the absence of any enabling provisions under Section 200A. The assessing officer processed the assessee's delayed tedious return and raised a demand for levy of fees under Section 234E by way of an intimation issued under Section 200A. The matter went up to the tribunal against the very intimation issued under Section 200A, where the tribunal considered the law as it stood then prior to June 2015 and the limited mandate of Section 200A. It ruled in favor of the assessee, holding that at the relevant time there was no enabling provision to raise a demand for fees under Section 234E. The tribunal further observed that intimation under Section 200A raising a demand or directing a refund to the tax deductor can only be passed within 1 year from the end of the financial year within which the related tedious statement was filed. That time had already elapsed and the defect was not curable at this stage. Hence, levy of fees under Section 234E was unsustainable in law. Our fourth case relates to the overseas credits received by the assessee from a discretionary trust overseas. The key issue in this case was whether the onus to prove that the credits earned by the assessee overseas was chargeable under Section 68 or not lies on the assessee or revenue. The assessee in the present case is an individual who had received in his bank account huge credit of $1 million from a trust registered in Channel Islands. The assessee, during verification, produced a certificate from the trustee overseas, Messrs. HSBC Republic Trust Company BVI Limited, to the effect that as trustees with powers of trust administration, they had sent the money from the capital account of the trust. Accordingly, such money was a capital distribution made to the assessee because he was a discretionary beneficiary since the establishment of the trust. The assessee accordingly claimed the credit as a capital receipt. Here are the case details.
On inquiry by the department, the assessee claimed that the trust could neither provide its financial statements nor reveal the names of the other trustees due to the secrecy laws prevalent in the Channel Islands. Further, there were no identification criteria for the trust like PAN as per the laws of the Channel Islands. After considering all such submissions, the revenue concluded that although the trust was a private discretionary trust, it was a foreign trust, and any fund distributed to any resident of India was chargeable to income tax in the hands of resident assessee. There were neither any DTAA between the countries nor any provision in Indian Income Tax Act to exempt such receipt. Revenue also noted that there was no evidence on record regarding the tax payment made by the trust in the country of its incorporation. In the absence of financial statements being produced by the trust, it could not be ascertained whether the distribution of the amount was made out of the income of earlier years, that is out of corpus fund of the trust, or out of the income of the current year. Hence, the payment was held to be a revenue receipt and treated as income in terms of Section 5.
The matter reached the tribunal, which ruled in favor of the revenue. The tribunal observed that whenever there was a change in the trusteeship, a memorandum had to be endorsed and permanently annexed to the settlement deed stating the names of the trustees for the time being and signed by them. It was clear that the assessee had not produced the settlement deed and had failed to discharge his onus that credit received by him was out of the capital fund of the discretionary trust. Therefore, the tribunal followed the famous decision of the Supreme Court in the case of Roshan Di Hatti, wherein it was held that in absence of proof, the revenue is entitled to treat any money as taxable income, and came to conclusion that the assessee is bound to prove the nature and source of the overseas credit to the satisfaction of the assessing officer in view of clear mandate of section 68. Before we go on to the next case, let's watch the promo of the upcoming episode of Simply Intoxicating, that is e-trouble at the rate of e-commerce.
After Industrial Revolution, the digital revolution which all of us are experiencing today is the next big phenomenon. And it is undoubtedly changing, rather expanding the contours of our existence, whether we live in cities or hinterland. And e-commerce happens to be the heart of this phenomenon. Whether we realize it or not, e-commerce is increasingly becoming an inevitable part of our daily life. However, this rapidly emerging industry is not without its own share of troubles, regulatory, fiscal, and many more. Watch out for our episode of Simply Intoxicating e-trouble at the rate e-commerce for an incisive analysis of all such issues by the domain experts.
The last case relates to application of section 194C on payments made under legal obligations. The key issue in this case was whether payment made on account of legal obligation would trigger provisions of section 194C. The assessee in this case is a public trust set up under Punjab Towns Improvement Act 1922. Here comes the case details.
A tedious survey was carried out on the premises of assessee, wherein it was noted that assessee had made payments to Punjab Water Supply and Sewerage Board without deducting TDS. Accordingly, demands under section 2011 and 201A read with section 194C were raised on the assessee. On appeal, the CIT appeal upheld the action of AO in principle, although restricted the demand only to the extent principal liability of recipient remained unpaid and in respect of the delay in eventual realization of tax.
The matter reached tribunal, which answered in favor of assessee by observing that payments made to Punjab Water Supply and Sewerage Board for execution of work relating to sewerage pipelines and for treatment of polluted water of the city was out of legal obligation rather than contractual arrangements, and accordingly, provisions of section 194C would not come into play. The tribunal made it clear that liability to deduct TDS would get attracted only in case of payments made out of contractual obligations. The tribunal therefore held that impugned demands under section 2011 and 2011A read with section 194C are wholly devoid of legally sustainable merits. With this, we come to the end of this episode of Legal Wrangle on Direct Tax. You may write to us your comments, criticism and counsel at editor@tiltube.com. Thanks for watching.